let's talk about the exam. Um, we're going to do it on Monday of next week. Since you have to take it on Canvas. My question is, I'm assuming y'all take it where you want to take it off online. You don't have to be here to take it. You need to be somewhere with a computer and an internet connection. Um, but do either one of you prefer to be here in class to take it
Uh,
with me watching?
It's not so much that as
If you
we
have
leave the
trouble-
notes and everything, I have.
Yeah, that's fine. That's fine. I mean, if you want to do it at home, that's fine. If you want to come here, that's fine. I just need to know if you yeah, exactly, yeah.
Yeah.
It's
I
140-mile round trip, but
I could say definitely I would take it at home.
okay. And can you do the same?
Yeah.
Okay. All right. So the assumption here will be you take it on your own, beginning at 5:30 to 8:25 or 8:30 next Monday. It won't take the entire time, I don't think.
And it'll just be pre-ready to open up at 5:30.
Just like a quiz, it won't be timed. It'll just end at it'll close at a certain date or a certain time. It will not be all essay, but you'll have a substantial amount that will be essay, and you'll have a number of questions that will be sort of short answer or lists. And I think also I'm going to put in as much as I can to a point. I think on Canvas, they're just fill in the blank questions. So if you misspell them, that's not a big deal, but I'll know what you're talking about. But what are we going to cover? We're going to cover chapters 1 through 10. Some chapters I'll probably, let's see. It's not, let me look at this. Let's look at the specifics of the class. And let's look at the syllabus, see what it says. Exams. Okay, so you know this. Exam number 1 is only going to cover the material that we ended with today. And you can use notes and readings during the exam. Just don't collaborate and receive assistance from anybody else. It's not going to be, a lot of this is kind of on your honor, and it's not going to be proctored. It's kind of a waste of time, in my opinion. And then here's a curving policy that we'll have that I doubt if it need to be a curve. How can we go about identifying things? What are some, okay, this is what I'll say. When you're studying, especially when you're looking at the cases, all right, think about, I'll try my best not to ask you any specifics about certain cases. What I'll ask you about is, tell me what this case either did or what it represented. What was the question? I may ask you, what was the basic question that this case was driven by or resolved? Okay, that's what's important. Like that previous one that we saw earlier in your textbook. Was it? Can we turn some lights on? Is that okay? I will ask you about the cases, though. That's a big part of this. I'm just going to go to chapter 10, for example. And like I said, Salazar versus Roma Navajo chapter, I'm not going to ask you about that. I'm not going to ask you about the Clean Water Act. So those are the last two. I may ask you Morton versus Mancari. So on Morton versus Mancari, what was the question? What did it resolve? It resolved that
they were that it wasn't utilized as race.
the Native American tribes are political and defined by the government as political entities. So it's a political relationship, not a racial definition, something like that. Okay. I doubt if the question would be that open-ended, like tell me what's significant about that. I won't ask you about Williams versus Lee. I don't really know why that was written there. Significant cases. I would like for you to, because I'll have I may even have some matching questions. So on a matching question, I might give you the statute or maybe the case, and then I'll have a description of that. And so you would match the case or the statute with the description. Okay. And you'll see some things that kind of allude to that in the second quiz, okay, if you get a chance to take that. I'm not going to just give you the same things over, but it'll give you an idea of kind of the depth of what I'm looking for. So we talked a little bit about the Indian Claims Commission earlier, right? And so on that one, for example, I could use that as one of the short answer questions or a list question. What were some of the drawbacks of a tribe entering a claim through the Indian Claims Commission? Just as an example. And so in that case, and I'll say, okay, identify five problems or five challenges like that, or I might say identify four. So in that regard, you wouldn't have to identify every single thing, but just make sure you come up with or three things, something like that. I will have, let's see, in terms of matching, I will sometimes use acronyms, okay? So I want you to be able to understand the acronyms, at least through chapter 10. And in chapter 10, the very last part of it, there's some discussion of programs and that popped up during the self-determination era, or that have popped up. And these would include the ICRA, the ICWA, the IGRA. Actually, we'll talk about those later. I don't know if I'll ask you about those. The Indian Gaming Regulatory Act of 1988. Indian gaming has its own chapter, so we don't need to really get into that yet. And repatriation is a big facet of the religion chapter, and that's NAGPRA, the Native American Graves Protection Grave Protection and Repatriation Act. Repatriation is returning to the rightful owner. So don't worry too much about those yet. I guess we should probably just go through the chapter. chapters. Okay, chapter 1, pre-USA foundations. I'm not going to ask you anything about the Spaniards or Columbus. But I will ask you some things about colonial British Indian policy. But probably not so much out of the textbook, because there's not really that much out of the textbook. I did talk about some things. What do you recall about that? What did I say about the British Indian policy?
They sent a representative. It was for protection from other tribes as well as other colonial powers. The treaties were designed for. They I think with them it was
Especially after 1763. British colonial policy, or British Crown policy was keep the peace, keep the colonists out of the Indians' territory. If I asked you this question, how would you answer it? What's a fundamental difference between British colonial Indian policy after 1763 and early United States federal policy with the Indians, in terms of who makes the law, who makes the policy? At least one thing I wanted you to get out of that was the British had a top-down crown. They call it the crown policy, right? So the British crown decided what was going to happen, and the governors of the colonies were usually responsible for bringing that, executing those policies. When the United States took over, however, the United States is democratic, and democracy and Indian policy, the democracy side of that means that it's going to be subject to the politics of the nation. So there's a lot less continuity through the policy. It's going to go back and forth. So, what if the American Revolution had never happened? What would it be like if we were just like Canada? We were just a part of the Commonwealth still, and we didn't have a Congress to foul things up all the time. All right. Well, certainly we would be talking in the early treaty era, chapter 2, the things that, what are the major items that you recall from that? Early treaty era. This is before John Marshall. Collier and Marshall mixed up. So before removal, what are some issues that, and really chapter 1 kind of covers them too. Sort of establishing the place of the Indian tribes within the developing federal system.
Oh, the dependent status?
Yeah. Even though it wasn't really articulated until John Marshall, the idea that the United States inherited from the British Crown this ultimate exclusive sovereignty, right? So the United States is working from this international law that, it's not an international law. It was just kind of it was obviously for, the powers in Europe. What would be in the early treaty era, what would be some important documents that came out that shaped relationships between the tribes and the United States? What was an important federal document before there was a federal constitution? Northwest Ordinance, yeah. And then after the Constitution,
The
Trade,
intercourse?
Trade and Intercourse, or the Non-Intercourse Act.
Uh,
I never really understood why they called it that so much, but yeah, there was a series of those. 1791 was a significant one. But, and then of course, where in the Constitution are Native Americans, what, in what ways, not where necessarily, but in what ways are Native Americans recognized? There's a lot of respect, right, early on, because they could overwhelm the new country fairly easily, and they would be, they would be allied with the British when the British were going to reinvade. So how are they recognized within the Constitution? I think I've got a Constitution here. Maybe not.
Commerce Act?
Hmm? The
Commerce.
Commerce Clause, yeah. The Commerce Clause, and that's basically the federal government has exclusive authority to conduct and manage commerce or interaction with other countries. In other words, the state of Georgia can't go make a treaty with France. The United States federal government does. And likewise, the state of Georgia can't go make a treaty with the Cherokee Nation. That's the federal prerogative. What else? How about in the counting of the population? The
Not tax.
decennial census plan, for the every 10-year count of the population, so that Congress can be reapportioned when it needs to be. So Native Americans didn't count because they were not considered citizens. They were not part of the United States nation. Okay. Anything else? Federal exclusivity over Indian policy. This is all the early treaty era. Really important one. The hierarchy of Indian treaties in the United States. How important are those?
They're up there with what, the law of the land?
Yes, they're law of the land. So this is Article 6, Clause 2. It says the Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. That's an old English common law phrase. And the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So basically, Indian or treaties, regardless of who they're with, Indians or foreign powers, Indian foreign powers, they're still treaties, and those treaties are the supreme law of the land, equivalent to the Constitution. That was the plan. Okay. Then came John Marshall. Most of the time in a history class, we're taught that John Marshall was the champion of Indian rights. But it turns out maybe he was, but he created some definitions that were twisted all over the place. Right? All right. So according to this textbook, the early treaty era ended sometime after Johnson versus McIntosh, but you should be able, for the exam, to be able to tell me the significance of Johnson versus McIntosh. What year? and really the whole background of it. So Johnson versus McIntosh, 1823. What's the next one in 1831? Cherokee Nation versus Georgia.
Right.
Okay. And then 1832. Sprinkle it on your steak.
The Worcester.
Worcester, yeah. Yeah. Worcestershire. It's actually just Worcester.
Yeah.
Worcester.
Yeah.
Worcester versus Georgia. And so each one of those, okay. What are some trivial things about it? Well, not necessarily true. Johnson versus McIntosh didn't include any Indian tribe. It just defined what? What did it do?
That was a tract of land that.
It had to do with the concept of original Indian title.
Yeah.
Okay. So original Indian title can only be removed by the ultimate sovereign. No land can be purchased by someone say, a United States citizen. It can't be purchased by a United States citizen unless the United States first purchase it or conquers an Indian tribe and takes it. Okay. So the reason for that is why. Basically, it's all built on the doctrine of discovery.
Yeah.
It's all that European, fiction that was created. So land cannot pass. Land cannot pass from an Indian tribe to anybody except the United States federal government. Period. That even goes for an allotment in Okmulgee, or Creek County or somewhere, that's still around today. When it goes to private hands, if it possibly can, probably can't, if it would have gone into private hands, it would first be ceded to the United States government. The United States government would issue a patent to the new owner, the allottee. Early treaty era. Lots of stuff here. I don't know if we want to get too theoretical. But the doctrine of discovery first, it certainly has a lot of influence over Johnson versus McIntosh. What do we call those three cases?
Marshall Trilogy.
The Marshall Trilogy. And the concept of Aboriginal title or original Indian title. What is original Indian title? That's a good one. Is it an actual document, like a deed, or a title to your vehicle? Like when you sell your car, you get to sign that title over. Is that what it is? No, not really. How is original Indian title different than so-called exclusive title held by the sovereign federal government?
Of the right to occupy.
That's part of it. The right of occupancy.
Yeah.
These, occupancy is actually a legal term.
Yeah. But not the right to extinguish or sell.
Not the right to alienate it, or you can say whatever you want, alienate it or sell it or dispose of it. Disposition is another legal term that refers to that. Disposition doesn't sound anything like what, but disposal. So the Native American tribe cannot get rid of the land except to the federal government. That's the rule. Okay. very colonial, very imperial. Let's see. Okay, Indian Removal Act. What did it do? What did it really do? Most people on the street would say, well, it removed the 5 civilized tribes from the southeast. But is that actually true? No. What did it really do? If you read the Indian Removal Act, does it sound so sinister? It gives the right of the executive branch to make treaties with the tribes, voluntary treaties, to exchange land in the east for lands in the west. It also provides for, at least in the law, it provides for the expenses. The federal government would pay for this. There would be new districts defined in this new Western Indian Territory, and those tribes would have clear boundaries of their domains. I think that's kind of a good deal, and that's really that's affecting us still today. Another thing, and this was Sarah and I were having a conversation yesterday about this, and the McGirt decision refers to the Creek Reservation, all right? But the term reservation came after the removal, and it came after the Indian Removal Act. I mean, it was, and the way the courts have interpreted this is, okay, well, we know what a reservation is, and even though the term wasn't around at that time, it's pretty much what they meant, right? But the fact is, the state of Oklahoma has used this argument forever. Those aren't reservations. Those were estates. Those were granted to the tribes. No other tribes that I know of received patents in common. I mean, basically real estate, privately owned real estate, right? There were reservations in the sense that the Rosebud Reservation is a reservation, because the Rosebud Sioux don't own it with a patent. They don't own it with like private property. They own it through Indian title. This is why I really wonder if the McGirt decision is actually correct. I mean, I think it's pretty cool that, it's Indian country now, but I don't think there were ever reservations in the sense that we understand reservations now. They were actually something more substantial. Basically protectorates. They were basically internal protectorates, kind of like what Russia has now and the Soviet Union had. Russia has these internal republics, basically, like Chechnya, cause them all sorts of headaches. Georgia, not an internal republic anymore, but it's the South Ossetia. These are internal republics of Russia, which were very similar, to what the 5 tribes were. They were their own internal things. All right. Removal era. So if we get into the other 2 Marshall Trilogy cases, Cherokee Nation versus Georgia, what do you remember about that?
They didn't hear it.
Yeah, it was not even heard. That's important to know. That's why it's important. It was thrown out because the Cherokees approached the Supreme Court as a foreign power. So they were bringing, I don't know if you call it bringing suit, I don't think you do, but they were bringing this up to the Supreme Court, which is the only body that can hear an international dispute with the United States. Right? So they were John Marshall in that sense said, no, y'all aren't international powers. You're domestic dependent nations, and so we can't hear you. You're not fitting the description. So we're not going to even hear this case. Now, what if John Marshall what if the Supreme Court would have taken that case? Things would be so much different. Well, anyway. And then Worcester versus Georgia. Did Worcester versus Georgia contradict Johnson versus McIntosh any? I have that on a note in my. If you looked at the PDF notes, sorry if you didn't look at them real closely, but if you think about this too long, like I tend to sometimes, you start wondering, okay, sort of his definitions are sort of getting mushy, over time. All right, so Worcester versus Georgia, what was it about? It was all about the role of states' relationships with tribes, with the nations. So, in that sense, what did it say? Well, Worcester was a non-Indian in Indian country, and the state of Georgia was, well, they had, we hereby nullify all laws of the Cherokee Nation. We don't recognize those. And you are now subject to the laws of Georgia within the boundaries of the Cherokee Nation. So when Worcester was hauled into to jail in probably Dalton, Georgia or somewhere, carpet capital of the world. When Worcester was hauled into jail, he appealed, to the Supreme Court, and the Supreme Court found that Georgia does not have jurisdiction over Indian country. They can't extend their laws into Indian country, and that's really substantial. Right? So that really began the rift between the states and the Indian tribes. That would come back in, PL 280, but unless Congress authorizes a state to have authority in Indian country, it doesn't. Not the states, but the federal government can. The federal government decide, we have jurisdiction over serious crimes in the Major Crimes Act of 1885, right? In Chapter 4, I made a note about a comment that regarding the overland trails through the Great Plains. Unfortunately, the author did not mention a very important treaty that was taking place at this time. And that's my mistake because I forgot about it too, because he didn't mention it. But the first treaty of Fort Laramie was 1851. And I didn't even talk about this, and I wouldn't really expect you to know it, but the first treaty of Fort Laramie it created a corridor for the Oregon Trail, okay, and the Mormon Trail, which is on the other side of the river, because they wouldn't allow the Mormons to follow along the Oregon Trail, and also part of the California Trail, and also the Transcontinental Railroad. Okay, so in 1851 they got that treaty with the Lakota and Cheyenne and others to, basically let the white people pass, right? Then in 1854, it doesn't really go into this at all. In 1854, the Kansas-Nebraska Act is passed. So Kansas and Nebraska territories come in. So then you have the extension of federal jurisdiction over into the Central Great Plains. And that's when there is, because after 1854, settlers poured into Nebraska and Kansas. And although it was a slow process, they, by 1860, they weren't anywhere close to, midway through what would become Kansas and Nebraska. But it did put pressure on the Plains tribes, who retaliated now and then. Okay. I did talk a little bit about the California Indians who, it was sort of like Sarah would remember this from another class. The Endangered Species Act. Remember that one? Is the Endangered Species Act a really good piece of legislation? Not always, because if the Endangered Species Act allows the federal government to protect a species no matter what, and even on private property. So if you find what's that pileated woodpecker, like woodpecker in Arkansas, that they're always seeing that is not supposed to exist, it's supposed to be extinct, but if it would be seriously endangered. So if you see that woodpecker that's super rare, it's protected. If you see one of those, well, the government's coming after you, right? And if you're already kind of paranoid about the government, which a lot of people in the region might be, then you might just take out your 12 gauge and make sure that woodpecker never gets seen by anybody, right? All right. I like woodpeckers. So that's the problem with that policy. So what's the point? The Environment or the Endangered Species Act. Did I say that? It's the Endangered Species Act. Not okay. So how is how is the story of the California Indians like the effects of the Endangered Species Act? That's not a laughing matter, sorry. I was laughing at the woodpeckers. In the case of the California Indians, the California Gold Rush, people realize we might be owing something to these Indians.
Just start picking them off.
If there was ever an example of, genocide going on in the United States against Native peoples, that's it. There's no question on that one. Organized hunts. So that's awful. All right, so the peace policy that's next in westward expansion. What do you recall about the peace policy? Who's behind that? And there were a lot of other things going on in Minnesota and Colorado. During the Civil War, what was the status of Indian country during the Civil War? I talked about a lot about Indian territory, right? So what would you say about Indian territory during the Civil War?
A lot of them sided with the Confederacy, didn't they?
Yeah, I think there were treaties. I think all five had treaties. At least one faction. The Chickasaws were pretty much united, but the Cherokees had a small minority of people who sided with the Confederacy. And other tribes were kind of split. One thing it did, though, it factionalized all the tribes to some degree. It vacated Indian territory because people either went north to Kansas or south to Texas. There was a guerrilla war going on that some historians around this region say was one of probably the worst conditions of anywhere outside of the main theater of war, in Virginia and Tennessee and Kentucky. So Indian Territory. So it split the tribes. What were the consequences of signing treaties with what General? What was his name? Albert Pike. Albert Pike of the Confederacy. What were the consequences? And the Union sympathizers were right. You know,
Recognized.
in the Cherokee Nation, they were called the Penn Indians, the Penn Cherokees. Or later on, they became known by a different name that they kept secret for a while, called the Catawbas. And those folks were the real traditionalists. They didn't have anything to do with slavery, but they realized that the United States was probably going to be hell to pay if they sided with the Confederacy. You know, the United States was going to come back. So what was the hell to pay after the war?
They took away some treaties, didn't they?
They forced them to rewrite their constitutions.
Yeah.
Yeah, the treaties of 1866 required rewriting their constitutions. They also lost half their territory as war reparations against the United States. There was hell to pay. All right, so and your textbook only has like a paragraph about the Civil War in Indian Territory. So we're in Indian Territory at the moment, so make sure you know what I talked about there. We're in Indian country actually right now.
It's still hot.
I come from the unassigned lands. All right. So, what was the peace policy? Who put that together, and how was it considered a certain period of Indian policy? Remember, there's this pendulum supposedly. I don't know. I'm kind of critical of that, but there's this pendulum, and it kind of makes sense if you look at the periods. Separatism, assimilation. Separatism meaning autonomy, do your own thing. Assimilation means just forget about this tribal stuff and be like us. All right. So the removal period is considered to be, even though it's forced removal, it's considered to be a separatist period because they're getting them out of the way so they can do their own thing. But then in the reservations are, the reservation period's part of that, sort of banishment, if you will. But nevertheless, the reservation itself allows, it was intended for Native peoples to be able to support their culture into the future forever. That was the promise that we made, the United States made. The peace policy, though, which came after, during the reservation period actually lasted a long time, into the 1890s. But the pendulum swung over here during the peace policy. That was totally an assimilation period, when the reservations themselves became places where missionaries were sent and government farmers were sent to try to educate, and children were separated from their parents in boarding schools and taught to abandon tribal culture. So the peace policy, first of all, who's associated, what president is associated with peace policy?
Grant.
Yeah.
Grant, U.S. Grant. Okay. So Grant, has good intentions, and who was Grant's sort of point person on the peace policy, or the civilization policy, if you want to call it that. Civilization is what they often refer to it as. We're going to civilize all of these Indians. Make them stay in one place, be farmers, quit hunting. They did a lot of things. I mean, this was social engineering. This is early American social engineering. They separated children. Another thing they did that was not discussed in the book, that I didn't talk about, was the whole, well, maybe it was discussed a little bit, the whole program of providing rations. You know what rations are, right? Foodstuffs. Because these people were, especially the Plains tribes, were unable to hunt after about 1874. Because they were unable to hunt, the government got into the government was providing basically flour, sugar, coffee, bacon, more flour, some beef. They were providing all of these food commodities to the tribes. And whether it was planned or not, it became a tool for manipulating the powers within tribes. Now, the Plains tribes are different from like the Muskogean and Iroquoian tribes that were relocated to Indian Territory or were remained in New York or whatever. Those Iroquoian and Muskogean tribes were matrilineal, right? And women had a big role in society. Plains tribes were different. They were patrilineal and warrior societies where the men had all the authority and the men maintained their status in society, usually through supplying and directing supplies of gifts and food and that sort of thing. So generosity was their friend, and so the more generous you were as a man, as a chief, the more beloved you were. The rationing and the way that the reservation system worked, and the Indian agents caught on to this, and they're talking to each other. The Indian agents know how this can work. They're saying, okay, we can undermine the authority of the chiefs by distributing these rations to everybody rather than to the chiefs, because initially they were just giving them to the chiefs and they would distribute them. So they undermine the authority of the chiefs and basically the men in general by distributing commodities, foodstuffs, and other things to every adult, to women as well as men. So they intentionally went after facets of the culture to try to destroy it. Okay, and of course, taking kids from their families and taking them to boarding schools far away where they would be, they would not see their families, and they didn't write, they didn't call on the phone. That was perhaps the cruelest examples, but they intentionally tried to break the tribal culture during the peace policy. Okay, and so during the peace policy, how did Grant transform the Indian service, I should say. So the whole army of bureaucrats and Indian agents, how did he transform that? Remember that Grant got a lot of flack. He got a lot of criticism early on in his presidency that the reservations were all staffed by these lackey military people who were no good. And, they were the ones that they didn't want to call into the theater of war during the Civil War. So these people were corrupt, or at least they were blamed for being very corrupt and, profiting from, taking commodities and selling them themselves. So that was clear. So what did Grant do to change that?
The Christian organizations.
He opened it up to Christian organizations who were, self-proclaimed benevolent organizations to come in and replace all of those people. So that was his idea of the peace policy, was to bring a benevolent force to the Indian service, Christianize them, and a lot of that was due to Grant's point man during the peace policy, who was, I can show you pictures of him. And I used
Parker,
to, Eli S. Parker, yeah, Eli Samuel Parker. And I used to read reports of the Commissioner of Indian Affairs every year. I would read those, and it would always say Eli S. Parker, and I thought, man, that guy is just like, he doesn't understand anything. He's like anti-tribalism. He's anti-American, anti-traditional religion, everything. And only later I learned, well, he was a Seneca. He was a Baptist Seneca. He was a Christian, highly educated guy, had all good intentions, I'm sure, but his intentions were Indian tribes are a thing of the past, right? And tribalism we should do away with it for their own good. They don't know it, but do away with it. And Parker often blamed the whole treaty process as setting the Indian people up for, basically inflating their expectations, treating them like sovereign countries was stupid to him, Anyway, so his point of view would not be alone. Later on, other people would have the same. People with good intentions working against Indian culture. All right, I'm trying to get through here. The Cherokee tobacco case, remember that? That was during the westward expansion phase. I might ask you about what that did. Allotment. Oh my gosh. We've talked about allotment. I'm sure you know way too much about that. What are two federal statutes that involve allotment? Two federal statutes that involve allotment. You should automatically think 1887, Henry L. Dawes, General Allotment Act, allotment and severalty. What does that mean, severalty? It's related to the word sever, cut, okay? So severalty, you're going to cut parcels out of the reservation and give them to individual Indian people. The other statute that you should automatically come to mind, especially if you're in Indian country right here, okay? Enid's not Indian country, sorry. That's that's unassigned lands, red dirt country. But the allotment of the 5 civilized tribes required the Curtis Act. Now the Curtis Act was just the what do they call it? This carrot and the stick. Well, was it a carrot or a stick? It was a baseball bat. Okay, so the Curtis Act was a baseball bat that forced the tribes to negotiate allotment agreements. Just like the Indian Removal Act, it didn't actually bring allotment itself. It was an act for the protection of the people of Indian Territory, all right? And for other purposes is what it was called. So that Curtis Act was the baseball bat that forced the tribes to negotiate agreements. And it was named for who? A congressman from Kansas named Charles Curtis, who was a full-blood Kaw Indian, okay? So allotment, and if we talk about allotment, then we talk about the loss of 90 million acres. Now that loss of 90 million acres, What does that mean? All that means is 90 million acres were taken out of reservations. They weren't lost necessarily to fraud, to whites. They were removed from the reservation land base. 90 million in total, something like that. Now, a lot of the land was actually lost to opening up of land runs, and those were called, the 90% of lands of reservations that weren't taken as allotments, those were referred to as blank lands, surplus lands, right? Surplus lands. Why were they surplus? Well, if every and this is a question on your quiz. I'll give you the answer here, or I'll give you the question at least. Did the allotments under the General Allotment Act, did they issue 160 acres to every person in the tribe, like the Homestead Act did? Well, Homestead Act only issued land to people over 21, I think. Maybe it was 8. I think it was 21, over 21. So if you're a child, you couldn't take out a homestead. But if you were a member of an Indian tribe going through allotment, children received allotments, women received allotments, men received allotments. Everybody received allotments, but women received half as much as men, and minor children who were not orphans received half as much as women. So 160, 80, 40. We talked a lot about Angie Debo and how allotments and how allottees were often swindled out of their lands by professional guardians, lawyers who basically signed up, many children usually to become their lawful guardian and take care of their assets. Okay, what did allotment do? How does allotment still affect us? How does allotment still affect Indian country today? There's this thing called checkerboarding.
Oh, yeah.
Okay, where you have a mosaic of restricted land and fee land, in some cases tribal land. It also created the big problem of administering all of the allotments and keeping track of the incomes and leases and so forth that the Department of the Interior had to approve before anything took place on the land. So it bloated the Indian Service. The Indian Office had to, expand greatly. And probably the problem that lasts to this day is the problem of what? And your author calls it one thing and I call it a different thing. Remember that? Your author calls it fractionalization. And I don't know where that came from, but it's probably the same thing as fractionization. Fractionization is what the courts call it. Fractionization, no, gosh, okay, now it's got me doing it. It's fractionation, not fractionization, fractionation. It's not hydraulic fracturing either. It's not fracking, it's fractionation. Fractionation is the division of a parcel of property many times over because of the problem of the restrictions on the alienation of the property. Right? What's a restriction on the alienation of property? So an allotment, if you received an allotment, that was your little plot of Indian title. That meant that you didn't actually own the property, you just had a possessory right, But if you stayed on that land for 25 years, if after 25 years, if you're still alive, then the federal government would issue you a patent and actually basically take the land, declare declare the Indian title extinguished, and then give it back to you and declare you a United States citizen. So the allotment process was intended to make white people of Indians, or make non-Indians of Indians. Okay, Native Americans are the only people in the history of the United States who can voluntarily change their ethnicity.
Wow.
At least it used to be that way. Change their racial, on paper, I guess, whatever. But that was the whole idea. If you had somebody living on this land and it was restricted, they couldn't sell it. They could only wait for the federal government to remove the restrictions to basically extinguish the Indian title characteristic of the land and then issue it to you like a homestead, like it did so many thousand homesteaders across the United States. Why was the restriction there? Because these Indians are incompetent. They can't manage their own financial affairs. They can't do these things. Well, of course, a lot of them could. So what followed the allotment program in 1906? In 1906, the Berkey Act came into play. So that meant that if you petitioned the Department of the Interior and you said, I'd like to have these restrictions removed because I'm competent and I can go to the bank and get a mortgage now if I get title, get a patent to this land, then people could remove the restrictions. What was the problem with that? I didn't really talk so much about it in class. The Berkey Act discriminated against people according to blood quantum. So full blood people could not petition the Department of the Interior, period. Okay? If you're like half blood, then you could petition like after 5 years or something crazy like this. If you were less than like half blood, then you could petition, something like that. It doesn't matter so much the details, but it was discriminatory about who could actually petition to have the restrictions removed. The other side of that is if you had a guardian, then you could have your petition, you could have your restrictions removed. The guardian could take control of it. Okay. Going back to fractionation, one of the later attempts to relieve fractionization came about in 1983 with the Indian Land Consolidation Act, which in 1983 sounded like a good idea. Basically, there are these parcels of land, and if you have a 40-acre parcel of land, and you have maybe 30 people who have their name on the 30 people who have interests in that parcel of land because it's restricted and it's been divided up into inheritance, and it's been inherited by several generations. And because it's got like 30 some owners, and all of those interests are of varying proportions, it's impossible to really make any money from it. And so the Indian Land Consolidation Act intended to take those sorts of lands and enact a term known as escheat or escheat, and that's basically where the land is returned back to the original sovereign. And in the case of the Indian Land Consolidation Act, if you had a parcel of land like that had so many owners and wasn't producing a profit of any real sense, that was returned to the tribe. But all those owners never received any compensation for it. So that was later challenged 1987 under Hodel versus Irving. I've talked about boarding schools and that sort of thing. I told you you'd get out of it early. Why I lie. You want to keep going? Or you need to leave? I can stick around. I don't care.
I'm
The
fine.
courts of Indian offenses, just if you need to sign off, just sign off. I won't get up there. All right. The courts of Indian offenses, that was in your textbook, those are generally referred to as the CFR courts, the Code of Federal Regulation courts. That was basically an administrative rule given by the Indian office regarding boarding schools. And basically the Indian office came up with, created their own laws, sort of misdemeanor laws for things like corporal punishment, this is how many swats or licks or whatever, lashes someone would get for stealing eggs out of the hen house. And I mean, there was an entire set of these laws that somebody wrote up in the Indian office in Washington and then dispersed out with very little oversight. All they had to do was publish it in the Federal Register. That was an administrative rule. Remember, we talked about all the different ways that Indian policy can be shaped? Administrative rules are the most sinister because they have very little oversight. Some bureaucrat just makes them up. Hi, I'm with the federal government and I'm here to help. Always be afraid of that phrase. Okay, we talked about the end of treaties, big one, right? 1871. What was the point of all that? Most of the time, the interpretation is that the declaration in the Indian Appropriations Act of 1871, that, oh, by the way, we're not going to do any more treaties. Sometimes that's blamed on a contest between the House and the Senate because the House had no real say in policy, but they were forced to bring appropriations to fund these things that the Senate would do. And so it was kind of a power play by the Congress or by the House of Representatives. On the other hand, it's also been interpreted as kind of like that move of the Indian office from the Department of War to the Department of the Interior, like that was some kind of symbolic deal. Doesn't mean anything because the Department of the Interior was created in 1849. And it just made more sense because the Department of the Interior had oversight over public lands of all sorts, the public domain, but also military reservations, Indian reservations. It made sense that it went there. So historians have said, oh, that's so symbolic, but it's not. It's just functional. The changing of the Congress's declaration that they were not going to make any more treaties was maybe a little bit more symbolic. But again, they made agreements, and those agreements were supposed to be analogous to treaties, but there was a difference. And that difference being that with a treaty, we have two parties, the United States and, say, the tribal negotiators, and they sit down and they iron through the whole thing and they say, okay, we're good, you're good, let's sign off. They sign it, document. Then the Senate has to ratify it. And that's done. It's a treaty. You can look it up on the OSU library website. On the other hand, an agreement works like this. Tribal negotiators here, government negotiators here, they work through all these things and say, okay, this is what we're going to do. You don't have to sign off on it, but this is the plan. This is what we're going to do. And then they take it to Washington, and it goes into committee. It's a law, okay? So it's going through committee as a bill, and then the committees strap all kinds of things to it, take things out of it, and to get it passed, they have to make deals with other parties, et cetera. And so by the time it's actually enacted, it can be completely different from what these people had attempted to negotiate. So that's the sinister part of it. No more treaties. We're just going to do things that we can change if we want to. Because we have what? We being Congress. We have the
Plenary power.
plenary power. And Congress began to realize all this. We've got all this plenary power. We can do whatever we want to here. And at the time, the Supreme Court was kind of a wet rag and was just kind of going with whatever Congress wanted to do. It's probably unconstitutional. Then we get into some cases, cases that you will definitely see on the test, and those would be another legislation like the Major Crimes Act. So what was the case? It wasn't a contested case, but what was the case that brought on the Major Crimes Act? Oh, here's a good question. I thought of this earlier. I'll ask it to you. Hopefully I'll remember to put this on the test. All right. How was Ex parte Crow Dog, 1883? How was that a catch-22 for Indian tribes? You know what a catch-22 is? The catch-22 is damned if you do, damned if you don't, right? So can you answer that right now? Ex parte Crow Dog, catch-22. All right, move on. Plenary Power 2, Chapter 7. And, if y'all need to leave, you go ahead and leave. Don't think I'm holding here. I like this chapter a lot. I like the previous chapter. He brings up this idea of a plenary power trilogy. I've never heard that before. I've studied this for a while. It makes a lot of sense. So what is the plenary power trilogy? It's U.S. v. Kagama. So you need to know each one of these. Lone Wolf versus Hitchcock. And it's U.S. versus Sandoval. So U.S. versus Kagama, that takes place in California. It has to do with the legitimacy of the Major Crimes Act. And it's really convoluted. Lone Wolf versus Hitchcock, in my sense, is probably one of the most important court cases in United States Indian history. Lone Wolf versus Hitchcock, and it involved basically it gave it affirmed. Let's put it this way: it affirmed plenary power of Congress. Okay. So you'll get some on Lone Wolf versus Hitchcock. It involved the Jerome Commission, or the so-called Cherokee Commission, as they were trying to allot the Cheyenne Arapaho Reservation down in southwest of Oklahoma. It was done completely corruptly. It was wrong. Yet the federal government just went through with it, knowing that it was unfair, because they had already let whites into the surplus lands, and there was no way they were going to get away with kicking them out. So basically, the Congress said, Congress didn't say we screwed up. Congress just says, we're not going to fix it because we don't have to. because we're Congress and we have plenary power. Sandoval involved the Pueblos, and that was a deal where this non-Indian was selling liquor on Indian land, and it involved citizenship. And you might recall that the Pueblos were special because they received title to their pueblos by the Spanish. They were declared citizens of Mexico when Mexico gained its independence. And then when the United States annexed the northern half of Mexico after defeating Mexico in the Mexican War, and the United States declared all Mexican citizens in this area are now American citizens, they accidentally declared the Pueblos United States citizens. Whoops. All right, so then they had to go back. They had to go back on that and say that, oh, by the way, even though you're United States citizens, you're still Indians. Therefore, we have a paternalistic obligation to treat you like we're treating all the other Native peoples. Okay, something like that. All right, so those are the three cases making up the plenary power trilogy, which I think is a really cool idea. Good interpretation. So, okay, let's see here. Treaties during plenary power. Again, treaties that I didn't really mention in the previous section, or actually the westward expansion section. There were two really important treaties that created reservations in the Great Plains, the northern part of the Great Plains and the southern part of the Great Plains. The first one was in 1867, negotiated in southwestern Kansas at Medicine Lodge Creek. That was the reservation that was the treaty that created the reservations in western Oklahoma with the Southern Plains tribes. And the Northern Plains tribes signed a treaty in 1868 at Fort Laramie. It's called the Second Treaty of Fort Laramie, and it established the Great Sioux Reservation. So with the various Lakota bands, there are a lot of bands of Lakota. You know the difference between Lakota and Dakota, right? Lakota, farther west, they're sort of the Western Sioux, and the Eastern or sort of Great Lakes Sioux are referred to as Dakota bands. Let's see, Lone Wolf versus Hitchcock, Sandoval, IRA, Indian Reorganization Act. Who do you associate with that individual? He was born in Atlanta, wealthy family. Was sent off to college and then eventually went to Paris. Learned about socialism and stuff. John Collier. Then he came back and he was housed by a wealthy art critic or art collector in Taos. Not sure exactly what was going on there, but anyway, it's kind of interesting to think about. And so he became very connected with the Taos Pueblo, and sort of got his ideas that American society can learn from Native American society, because American society is too materialistic. They are future oriented. They don't live in the here and now. It was positively influenced by Taos people, but so then he became a very big critic of the Indian office, which was deserved, but he was, of course, hired by Harold Ickes who was the Secretary of the Interior under Roosevelt during the New Deal. And that's when he implemented his Indian New Deal, the Wheeler-Howard Act, known generally as the Indian Reorganization Act, or the Indian New Deal. And that, of course, was a sweeping change from allotment, which was very much assimilation, to separation. So the Indian Reorganization Act is considered a separation. However, you could probably make an argument that it's separation, but it's separation that inserts the big federal government inserts its tentacles into the Indian tribes again. How does it do that? And by the way, I didn't mention the Merriam Report. Merriam Report's a very important document, so I'll want you to know about that. And it was published in 1928 by the organization that would become the Brookings Institution. But how is the Indian Reorganization Act an example of benevolent big government? And I say benevolent with, tongue in cheek. Well, nobody wants to answer.
Didn't they really want to keep the idea of like the Native Americans were the wards of the federal government?
Well, I think Collier wanted to write Indian tribes into the Constitution. He wanted an amendment that would give Indian tribes a status of some sort, kind of like the states. Of course, that wasn't going to happen. But what I'm getting at is, it was still paternalistic because Indian tribes were basically given a cookie cutter constitution, like fill in the name of your tribe in these blanks, okay, and then turn that into the teacher, and that'll be your constitution, okay. And the other side of that is, if the tribes wanted to create their own constitutions, they were asked to do that. Those constitutions had to be voted on by a majority of people in the tribe. So the United States was imposing majority rule on societies that didn't always live by majority rule. And finally, the constitutions had to be approved by the Secretary of the Interior. Basically, the BIA had to approve those constitutions so they could, edit them if they didn't look right, if they didn't sound right. So, still paternalistic. By the way, most of those constitutions are still in effect, but not all of the tribes, not every tribe bought into it. A lot of them just said, this is the federal government saying they're going to help us again, and you know how that works. So they didn't. John Collier kind of got a dose of reality on that one. Let's see now. Collier was a really, really interesting human being. I mean, fellow. He was the longest acting commissioner of Indian Affairs, I think. But after World War II, we get into the termination era, and I kind of began the show today talking about the termination era, so I think I'll probably just skip that. Indian Claims Commission, okay, and then House Concurrent Resolution 108, right, and Public Law 280. He doesn't mention how it doesn't mention 108 very much in this chapter, does he? Now that I think of it, it's just all about the PL 280. Really, PL 280 can't be overemphasized. He really doesn't spend much time at all on it, and it's incredibly significant because it has screwed up, Indian policy in many places. Thank goodness Oklahoma was never one. So we talked about all of this, I think. So termination, then that goes into self-determination. And just remember, Richard Nixon, for some reason, got left out of this chapter. I don't know why. Kind of have a reason. I kind of have an idea why, but I'm not going to say that. I don't know for sure. Maybe the author just completely lost his notes or something. But Richard Nixon did a lot of positive things for tribes that are still around. Self-determination we're still in that era of United States Indian policy, and hopefully this is the last era of Indian policy, hopefully. Except maybe a constitutional amendment that actually places Indian tribes within the United States federal system, which I think would be a great idea. But you know how that goes. Every time they want to fix, it usually screws something up. So, all right, 8:52, and I'll have some grades for you next time. But you've got another quiz, and then I'll hopefully get this other quiz up for you tomorrow soon. Those are going to be due at midnight on Monday, but just be sure you read everything. Read each chapters, like first 3 chapters, and then 4, 5, and 6. That's the one I just posted, and then it's going to be 7, 8, 9, 10. Okay, so that's a long one, but they're only 10 questions. So.
Oh, total? Oh wait, you're talking a quiz.
Quizzes, yeah.
Yeah, I got all excited there for a second.
And you got 10 minutes, so be ready. Be ready. The idea is to get you, in shape for answering those questions. But it's only a 100-point test. I can't possibly give you that many questions. All right. Have a good evening. I'm going to leave.